My name is Claire Timmons, and I will be presenting on Hanlon v. Berger. Here are the facts and background. In 1993, a warrant was issued authorizing the search of Paul and Irma Berger's ranch in Montana. The purpose of the search was to look for evidence of the taking of wildlife, which was a violation of the federal law. During the warranted search, a fleet of multiple vehicles carrying government agents, photographers, and reporters from CNN proceeded to the ranch. The media crew was authorized to follow and observe the search by the federal officers present. Thereafter, the Bergers filed a lawsuit against the officials, the special agents of the United States Fish and Wildlife Service, and an assistant United States attorney. They stated that they had been violated under the Fourth Amendment due to the presence of the media. They stated that this violation was because the media's presence constituted an unreasonable search. The district court came to the conclusion that the officials were entitled to qualified immunity, as no clearly established law protecting individuals from the commercial recording of a search of their premises existed at the time. However, because of disagreement on the decision from the higher court, the case carried on to the Ninth Circuit Court of Appeals, and they reversed the district court's decision. Here is the decision. The case made its way to the Supreme Court due to the lower court's conflicting interpretations. The Ninth Circuit Court initially found that the presence of the media violated the Fourth Amendment and ruled against the agents. However, in a previous related case, the Fourth Circuit Court found that the media's presence did not violate it. On March 24, 1999, in an 8-1 decision for Hanlon, the Supreme Court concluded that the agents violated the Fourth Amendment. However, they held immunity because the law was unclear at the time of the search. Stevens, the lone disagreeing opinion in the decision, did not write a dissent. The Supreme Court vacated their previous judgment and remanded the case back to the Ninth Circuit Court in light of their decision. The per curiam opinion of the Supreme Court stated that police violate the Fourth Amendment rights of homeowners when they allow members of the media to accompany them during the execution of a warrant in their home. We also hold there that because the law on this question before today's decision was not clearly established, the police in that case were entitled to the defense of qualified immunity. Here is some relevant law. The core of the case revolves around the Fourth Amendment, which protects individuals from unreasonable searches and seizures. Also present is qualified immunity, which is a judicial doctrine that protects government officials, including police officers, from liability for damages in civil lawsuits when their conduct does not violate established statutory or constitutional laws. Lastly, reasonableness is a concept held under the Fourth Amendment that requires searches and seizures to be conducted in a manner that is not excessive or disproportionate. As alluded to earlier, Wilson v. Lane is very relevant. Here is the background. While executing a warrant to arrest Charles Wilson's son in his home, deputy federal marshals and local sheriff's deputies invited a newspaper reporter and a photographer to accompany them. The warrant made no mention of such media ride-along. Charles Wilson sued the officers for money damages and contended that the actions of the officers violated his family's Fourth Amendment rights. The district court denied respondent's motion for summary judgment on the basis of qualified immunity. In reversing, the Court of Appeals declined to decide whether the officers' actions violated the Fourth Amendment, but concluded that because there was no established law constituting the media's presence as a violation, the officers were entitled to qualified immunity. The Supreme Court decision in Wilson v. Lane held that the Fourth Amendment protection against unlawful search and seizures prohibited the police from bringing members of the news media into private homes while executing search warrants. However, the court also found that the police officers involved were entitled to qualified immunity because the principle prohibiting accompanying media when searches were being executed had not been clearly established. Wilson v. Lane shares clear similarities with Hanlon v. Berger in content and outcome. Wilson v. Lane occurred before Hanlon v. Berger and, as stated earlier, influenced its outcome. Here is Hanlon v. Berger's importance to media and law. This case showcases the complex relationship between the right to privacy and media access. The media plays an important role in keeping the public informed. However, a balance must be found to ensure it does not infringe on individuals' rights to privacy. Both Hanlon v. Berger and Wilson v. Lane help to establish parameters within warrants and the presence of the media. The court concluded that a warrant does not automatically allow the media to be present. Their presence must be related and cannot be used as means for solely increasing visibility to the public. Thank you for listening. Here are my citations. Does anyone have any questions?